Hey everybody, and welcome back to Sip and Talk. All right, you ready to dive into another one of these deep dives? I am so ready.
I'm always ready for a deep dive, especially when we've got questions like the one we got today.
Okay, so speaking of questions, this one comes all the way from Taiwan.
Really, all the way from Taiwan? That's awesome. What are they asking about?
Well, they want to know why the UK doesn't just ditch one of their legal systems.
Wait a minute, hold on. The UK has two legal systems.
Yeah, apparently they do. I was kind of surprised too. I always thought law was, like one set of rules for everyone.
Yeah, it makes sense to think that, but the UK is kind of a special case.
So, okay, let's break this down for everyone listening. So two legal systems. What's the deal with that?
Okay, so basically the UK has two main legal systems. You've got England and Wales, which operate under what's called common law. And then you have Scotland, which uses a mixed system.
Common law mixed system. This is already making my head spin.
I know it sounds complicated, but it's actually pretty interesting. So common law is all about precedent, which basically means that judges' decisions in past cases actually become part of the law, like a rule for future cases.
So if a judge makes a ruling on something today, that ruling can influence how similar cases are decided in the future.
Exactly. It's like this ever-growing body of law built on what's come before, and there's even a fancy Latin term for it, stare decisis, which means to stand by things decided.
Stare decisis. I'm going to try and use that in a sentence today. Okay, so England and Wales, they're all about the precedent. But what about Scotland? What's their mixed system all about?
So Scotland, they blend in common law with elements of Roman law. So they pay a lot of attention to written laws passed by their parliament, which are called statutes.
Okay, statutes. So it's kind of like they've got this combination of looking at past rulings and following the specific laws written down.
Exactly. And this difference in approach can lead to some really interesting and sometimes quirky outcomes in their legal systems.
Quirky. Okay, now you've got me hooked. Spill the tea. What kind of quirks are we talking about?
All right. So in Scotland, one of the most unique things is they have a verdict in criminal trials called not proven.
Not proven.
Huh.
What is that like? Are they saying, yeah, we're not really sure if they did it, but maybe not?
Laughs. It's kind of like that. It basically means the prosecution hasn't been able to convince the jury beyond a reasonable doubt that the defendant is guilty, but it's not the same as a not guilty verdict, which suggests innocence.
So it's like this weird middle ground. You're not convicted, but there's still this question mark hanging over you.
Yeah, exactly. You're free to go, but people might still be suspicious. And Agatha Christie, the mystery writer, she actually called it one of the most Scottish things there is.
I laughs. Only in Scotland, right? All right, so what other differences are there between these two systems?
Well, another one that's really interesting is the concept of double jeopardy. You know, that rule where you can't be tried for the same crime twice.
I've heard of that. I'm pretty sure that's a thing in the U.S. too.
It is, but in the UK, they actually made a change to the law back in 2005. They allowed for retrials in really serious cases if there's substantial new evidence that comes up.
So there are exceptions to that double jeopardy rule in the UK. Was there like a specific case that really pushed for that change?
Yeah, absolutely. The murder of Stephen Lawrence, a black teenager who was killed in a racist attack back in 1993, that case was a huge turning point.
I remember hearing about that. It was a really tragic case what happened.
So basically there were initial investigations and trials, but no one was convicted, and there was a lot of public anger and questions about how the justice system had handled the case.
Yeah, I can imagine it's like people felt that justice hadn't been served.
Exactly. And then years later, new forensic evidence came up, DNA evidence specifically, but because of the double jeopardy rule at the time, they couldn't retry the suspects.
Wow. So they had to change the law itself to be able to revisit the case with this new evidence.
Right. And that change eventually allowed them to bring the suspects back to court, and they were convicted. So it just shows how even these fundamental legal principles can evolve over time, especially when there's a strong push for justice.
It's pretty amazing. Like the legal system itself had to adapt to make sure justice could be served in that case. Okay, you mentioned earlier that there were some historical differences in how the UK's legal system operated. Fill me in on some of that.
Okay, so imagine this back in the 18th and 19th centuries in England and Wales.
Right.
They had judges who would literally travel on horseback to different towns to hear cases.
Judges on horseback? Are you serious? That sounds like something out of a movie.
I know, right? They were called circuit judges, and they held these assize courts, and this practice continued all the way up until 1971.
1971, that's not that long ago. That's wild. So they were literally riding around dispensing justice from town to town.
Yeah, pretty much. And then speaking of historical things, have you ever wondered why judges in England and Wales wear those white wigs?
Oh yeah, the wigs. Those are iconic. I always just assumed it was some kind of tradition, but what's the story behind them?
Well, it all started back in the 17th century, and it was actually a way to distinguish judges and symbolize their authority.
Huh. So it was like a status symbol, a way of saying, hey, I'm the judge, listen to me.
Exactly. And while you don't see them as much in civil cases nowadays, they're still very much a part of the tradition in criminal courts in England and Wales.
It's interesting how these traditions can stick around for centuries. They're like a visual reminder of the history of the legal system. Okay, so we've talked about judges on horseback and fancy wigs. What about some of the actual cases themselves? Any record-breaking trials in the UK?
Oh, yeah, definitely. The longest criminal trial in British history was the R.V. Maxwell case. It went on for a mind-blowing 18 years.
18 years? You kidding me? That's longer than some people's entire careers?
I know, right? It was a massive case involving fraud and bank fraud. Just imagine the amount of paperwork and legal arguments that must have been involved.
I can't even begin to comprehend it. Okay, so we've covered some serious legal ground here, but you also hinted at some bizarre laws earlier. I love a good bizarre law story, so lay it on me.
All right, so get this. Have you ever heard that all whales technically belong to the king?
Wait, the king owns all the whales? Is that some kind of joke?
No, I'm serious. There's this ancient law from 1324 called the Statute Prerogativa Regis, which states that the heads of all whales and sturgeons found in UK waters are the property of the king, and the tails belong to the queen.
Laughs. That's incredible. So if you happen to catch a whale off the coast of England, you're supposed to, send the head to Buckingham Palace.
Well, technically, yes, the law is still on the books, but it's not like anyone is actually enforcing it these days.
Okay, so it's like one of those laws that everyone just kind of ignores. But it brings up an interesting point. It connects back to our listener's question from Taiwan about why the UK doesn't just get rid of one of its legal systems.
Exactly. It highlights how sometimes laws or even entire legal systems can stick around even if they seem outdated or even a little ridiculous. And there are actually some interesting parallels between this and Taiwan's claim to mainland China.
Okay, I see where you're going with this. So it's not just about what's practically enforceable, but also about the historical and political implications of changing things.
Right. You have to think about it as the difference between a law officially existing on paper and a law actually being applied in everyday life.
Like with the whale law, no one is expecting King Charles to go around demanding whale heads.
Yeah.
But the law itself still exists.
Yeah, exactly. And similarly, Taiwan's constitution might include mainland China as part of its territory, but the reality of the government's control is quite different.
So these things kind of exist in this gray area. They're officially there, but their practical impact might be minimal. But why not just get rid of them then if they're not really doing anything? Why not simplify things?
Well, that's where the political risks come in, and just the sheer effort involved in making such big changes. You see, changing laws, especially ones that are deeply rooted in history, can be a huge political headache.
So it's like you don't want to stir up unnecessary controversy or open a can of worms by trying to change things that have been in place for a long time.
Right. For the UK, trying to identify and reform all of these old laws would take up a lot of time and resources that Parliament might want to focus on other more pressing issues.
And for Taiwan officially changing its stance on mainland, China could have huge consequences for its relationship with Beijing.
Exactly. It's like that saying, let sleeping dogs lie. Sometimes it's easier to just leave things as they are.
Okay, so it's like a combination of practicality and political strategy. But what about the symbolic value of these things? Do these old laws or claims still carry any weight culturally or historically?
Oh, absolutely. Traditions like the judges' wigs in England and Wales, they might seem a bit odd to outsiders, but they're a part of the legal culture there. They represent a connection to the past.
It's like a visual symbol of the history and evolution of their legal system.
Exactly. And in the same way, Taiwan's constitutional claim, even if it doesn't perfectly reflect the current political reality, it still holds historical and symbolic significance for many people.
So it's like a statement, a symbol of something that's important to them.
Yeah, and this kind of ambiguity can actually be useful in international relations, too. It allows for different interpretations depending on the context.
So it's kind of like a diplomatic tool in a way that's really interesting. Okay, so we've talked about the political and symbolic reasons, but are there any practical or technical difficulties in maybe merging or abolishing one of the legal systems in the UK?
Definitely, you see these older laws and legal precedents are often tangled up with a bunch of other regulations and frameworks, so trying to untangle them could be incredibly complicated.
It's like trying to pull one thread out of a giant messy knot. You might end up unraveling the whole thing.
Exactly, and constitutional amendments, like the one regarding Taiwan's territory, they often face really high legal and political barriers. So it's not just a simple matter of voting to change something.
So sometimes it's actually easier and less disruptive to just leave things as they are, even if they seem a bit strange on the surface.
Right. Sometimes keeping things as they are, even if they're a little bit odd, can actually provide a certain level of stability.
Okay, so it's a mix of factors: historical significance, political sensitivity, practical challenges. It's all starting to make more sense now, so we've focused a lot on the UK. But I'm curious, how do other countries deal with this idea of having different legal approaches within their borders or these outdated laws hanging around?
That's a really good question. So if you look at the United States, for example, they put a huge emphasis on the idea of equal protection under the law.
Yeah, I've always heard about that, the idea that everyone should be treated the same under the law no matter who they are.
Exactly. So any legal distinctions based on things like race, religion, or sex face serious constitutional challenges in the U.S., their legal system is really focused on making sure the law is applied fairly and consistently across the board.
Got it. So it's all about ensuring equality and fairness for everyone. Okay, what about other countries?
Well, Taiwan, their legal system has been heavily influenced by continental law traditions, which also have some similarities with Scotland's system, though they're distinct.
Okay, so what does that mean for how their legal system works?
Well, in Taiwan, there's a strong emphasis on the uniform application of written laws, and judges generally have less leeway to consider individual circumstances or someone's background when making a ruling.
So it's more about sticking to the letter of the law and making sure it's applied consistently.
Exactly. The focus is on predictability and uniformity in the legal system, and similarly, Japan, their system also values legal uniformity and judicial neutrality. Any distinctions made based on someone's background could be seen as going against that neutrality.
Interesting. So different countries have different approaches to these concepts of fairness and equality under the law. It really shows how diverse legal systems can be around the world.
It really does. And speaking of diverse and interesting things, I have to tell you about our friend Micky. He has this amazing YouTube channel called Mickytolife.
I love a good travel vlog, especially when there's whiskey involved.
Oh, and he also makes his own music.
Yeah.
He's incredibly talented. He's got this one song.
Sings a made-up tune. Like that. Okay, I'm sold Micky to life.
Yeah, you definitely should. We'll put a link in the show notes for everyone to check it out.
Awesome. So we've talked about legal systems from the UK to Taiwan to Japan, and even had a little musical interlude. But circling back to our original question about the UK's two legal systems, it's clearly a lot more complicated than just saying, okay, let's just have one set of rules for everyone.
Right. It's not that simple. It's all tangled up in history and politics and tradition. And sometimes it's just easier to leave things as they are, even if they seem a bit unusual.
It makes you wonder how many other things we just accept as the norm without really questioning why they are the way they are.
Exactly. And a huge shout out to our listener in Taiwan for sending in such a thought-provoking question. It really got us thinking.
Absolutely. And maybe the next time we find ourselves debating something, we should all just take a moment to remember the king's claim to all the whaleheads.
That's a good one. It definitely puts things in perspective. So what about you? What are some other seemingly strange or outdated systems or laws that you've come across, and why do you think they persist?
That's a great question. And I think it's one we can all ponder as we go about our day. Keep those brains buzzing, folks, and we'll catch you on the next deep dive.
See you then.